Ladies and gentlemen, it's a privilege and an honor to have been asked to make a presentation before such a distinguished gathering, a gathering which includes scholars, academics, researchers, and above all, those who actually are a voice for those millions of living beings who suffer in silence. I would just start I would just explain that my presentation is in 3 parts. The first part, as I was mentioning to Raphael, that as a student, I was not very impressed with the American realist theory. But when I was elevated as a judge, and as a judge, my experience is that the theory is probably not misplaced, because we all are human beings, and the rules or the statutes, the legislation may be there, but ultimately it is the judge who has to interpret the law. So I'll start with the influences that I've had in my life, and then I'll come to the judgment, and later the most important part is to have the judgment implemented. Ladies and gentlemen, that is important because at an early stage I'd read a very amazing book by Justice Stephen Breyer, a judge of the United States Supreme Court. And the title of his book was Making Our Democracy Work. The title was a bit misleading, but the lesson or the message for every judge was that though it is important to give a declaration, but it is more important to ensure that the judgment that a judge delivers is also ultimately implemented. So it was a matter of first impression, and it was important because now you must be wondering what does a primary school has to do with it. It was just a coincidence that as a child, I had studied in this school, which is across the Regent Street. And I also lived there for about a year. It was at a walking distance from the London Zoo. And let me, at the very outset, say that I do not in any manner undermine the laudable work that the London Zoo has done and continues to do as far as conservation is concerned, but it is still a captivity. And in the mornings, at that time, many years ago, we could hear occasionally the roars of the lions. But in the school, we were shown images of the lions in a savanna and the orca whales moving around in their pods in the oceans, elephants in the herds. But then going to the zoo was very confusing. And we were in the heart of London, and such a contradiction for impressionable mind. It was difficult to reconcile, but it did raise certain questions. This is only what the present website says about the land of the lions, that it is designed to inform, inspire, and excite wildlife lovers of all ages. With great respect, as a child and with my experience, I do not agree that it actually excites or informs the people. It raises questions. When I took the law degree, when I was taking the admission, one of the subjects that I chose was Usul al-Fiqh. Usul al-Fiqh is in fact the methodology or principles applied in Islamic jurisprudence for deriving the rulings of Islamic law, which you know as the Sharia. The Sharia actually is different from probably whatever perception there is, because what we were taught was that the edifice of this principle is premised on the principle of preservation of life, and life in every form. But then that is a message of every scripture, whether that's the Holy Bible, the Torah, the Guru Granth, or the Bhagavad Gita, the Buddhist, even a human being who does not believe in religion would not deny that the basic principle is preservation of life. But I'll come to that later. Now this is very interesting because for masters I came to this great university. And at that time it was inconceivable that human rights law would ever be offered as a subject. So I chose the civil liberties. And in the first class I was a bit surprised because except for two students, that's myself and another one, all others had come from the developed worlds. And I was quite surprised that why should developed world be interested in civil liberties so as to study it as a subject. But we had some great teachers, Sir David Williams, Professor Stephanie Palmer. They actually convinced us that it protects the human beings. And it was here, this photograph that you see is of a Congolese who was brought to the Bronx Zoo, and the New York Times had actually titled it as "The Bushman Caged with the Bronx Park Apes." Now, why I'm emphasizing this? That humans actually did not treat certain humans as humans. So they were not persons, and they were not treated as legal persons. But that was not the only example. There were human zoos till recently in all the major cities, and where people would throng to see the primitive natives. And then the slavery itself. But these social norms, unjust norms, and this social change came about through the movements of civil liberties and through understanding. What I'm emphasizing is that animal rights was never taught as a subject. No one was interested, but that momentum for that change is quite visible now, that yes, at least in a way it is felt, at least it is debated, that these social norms, the way animals are treated, are denied their rights, that is unjust. And I've taken this quotation from one of his very outstanding documentaries, where he interacts with the gorillas in the wild. And this is why I'm mentioning this, is only to emphasize how a one man through a documentary can redefine the perceptions about anything. And this is what he had to say. It seems very unfair that man should have chosen the gorilla to symbolize all that is aggressive and violent, when that's one thing the gorilla is not, and we are. So we are because we dehumanize human beings, and that is how we violate the rights of our own fellow human beings. And then I was elevated to the High Court of Islamabad as a judge. That's a constitutional court, and we have a written constitution. And the common law writs are part of that written constitution. And habeas corpus, as well as mandamus, are one of the writs that can be granted by a constitutional court. So the expression person has also been defined, but it doesn't say that person, it's not an exclusive definition, but an inclusive definition. So I could have, in the Supreme Court, while dealing with other than human beings, there was an opportunity to develop the law, but why I didn't do so, I'll tell you later. But in the High Court, I was mostly dealing with fundamental rights, and human rights were in litigation. There were enforced disappearances, there were prisoners' rights, there were women and children's rights involved, and there was destruction of the natural habitats. That was easy, but here the difficulty arose when 3 petitions were filed and they were fixed in my bench. In the first petition was regarding a bear. The bear was confiscated by the Wildlife Board, and temporarily that was caged in the Islamabad Zoo. And the zookeeper refused to release that bear to be shifted to a bear sanctuary. The second petition was by a citizen, and that explicitly was regarding the welfare of Kaavan, the elephant. And the third was by another citizen regarding the treatment as far as the stray dogs were concerned, because they were treated in a way subjecting them to pain and suffering. So it was something all of a sudden, and altogether questions of first impression being raised before me. Now, it was very easy. I mean, whether the approach should have been to take it as a welfare petitions or petitions that actually prayed for a declaration that non-human animals are also conferred with rights. So it was a proposition, and a difficulty there that I faced was that all 3 petitioners, though they were citizens and very, very passionate citizens, but they couldn't afford expensive lawyers. But the lawyers, young lawyers, they were very passionate about it. And as a subject, it is not being taught as a law in the educational institutions of Pakistan. So the World Wildlife Fund Pakistan was appointed as amicus, and they submitted a report. And these were the inmates in the zoo. And it was not just the elephant Kaavan, but there were 878 non-human animals, 89 mammals, 769 birds of 38 different species. There was an elephant, there were Himalayan bears. Imagine Himalayan bears in the scorching heat of Islamabad, a marsh crocodile, lions, wolves, monkeys, ostriches, and many others. So the petitions were in the context of welfare of the animals, and the prayers were also to minimize the sufferings of the non-human incarcerated inmates and to ensure the compliance of their conditions with minimum standards. But there was no petition on behalf of the other inmates. As a constitutional court, the High Court was not vested with suo motu jurisdiction, but it certainly had the power to and jurisdiction to mold the prayer. So a question was raised before the lawyers and the amicus who was assisting the court whether there is a right to live in natural habitats and not the artificially created habitats by human species. Or in fact, the question that was raised by the court was whether the non-human species, living species, do enjoy and possess rights. Well, there was another difficulty. The amicus and the lawyers were hesitant. They wanted relief by way of welfare of the animals. Probably they didn't even believe that a high court would shut down an entire zoo. So the amicus brief also made recommendations which were not in the context of the rights of the animals. And again, for this jurisprudential challenge, it was important to survey the evolving jurisprudence around the world. And at that time, I didn't know that the Cambridge University had established its Animal Welfare Society. Otherwise, I would have definitely contacted Raphael for assistance. But I surveyed, and I must say the credit goes to my associates who did a good job. The only judgment which does not is not mentioned here is from the Constitutional Court of Ecuador, because that was rendered subsequently, and it had not been rendered by the time when the proceedings were ongoing. But the jurisprudence, for me, I took time to comprehend the jurisprudence. The jurisprudence that has developed in Argentina actually looks at certain specific qualities which are similar to humans. So a connection is made, despite its groundbreaking judgment, a somewhat connection an attempt is made to connect it or have a link with the humans. Similarly, in India, the judgment that was rendered in 2014 actually equated the rights of the non-human animal species with the humans. That was also that approach with great respect, but as I know, the Indian judgment probably this year has been overruled, or a 5-member bench has decided differently. So in the United States, and I must, this morning I was talking to Raphael and I was mentioning to him that I was actually impressed by the relentless effort made by the Non-Human Project and Professor Stephen Wise and his team, that they have actually developed a jurisprudence, but there the jurisprudence links the rights with personhood, and it has been restricted to humans. So a legal person can only be a human, and only a legal person can have rights. But going through the judgments, though not explicitly, but implicitly or indirectly, the judges actually do acknowledge that they are not things, that they are not merely a property. They are more than that. So the recognition of the rights are already there, but the confusion or the contradiction is that somehow that legal concept of personhood has become a problem. Now, all this was before me, so how did I approach that? Well, I thought that humans are not the only living beings on this planet. This planet is shared by many living beings. So, what would be the source or foundation of human rights, for instance? Do human rights exist merely because we are humans? Is our intrinsic value or our interests only because of being humans, being a particular species, or is it because we are intelligent, we have the ability of consciousness? But there were several questions there as well. What about an infant? What about a human being who is on a ventilator, who may not even be a sentient enough, you see, to feel anything? So there were difficulties, but as far as my mind was concerned, it was not very convincing that the basis of a legal right should somehow have a link or connection with human beings. Now, person as an expression is also a term of art. It has been interpreted by human beings. The constitutions have been framed and they exist for regulating the conduct and organizing the human beings, just one species. So what about the other human beings? Well, I came to the conclusion that the source of even the human rights, its inalienability, its being inherent, and that intrinsic value is because of one attribute, and that is life. And now, if there is no life, there will be no rights. No one can claim a right, and no one can claim a right on behalf of someone else. So, even, you see, when the Universal Declaration of Human Rights, when that was adopted in 1948, there was no legislation. The states had not legislated on that, but it was based on the intrinsic value of human beings, which was premised on the most valuable factor, which was life. And that is where the judgment materialized. Now, the judgment actually says that, whether you accept it or not, but implicitly or explicitly, directly or indirectly, no one would deny that the non-human animal species do not possess rights. And as I said, the rights, they actually stem from the attribute of life. If there is life, there would be legal rights, and if there is no life, there will be no. And that is my reasoning actually made me to conclude that yes, the non-human animals, they possess rights. Now, I'm also of the opinion that every living species, they possess rights. But how those rights would be classified? It was no one's case that Kaavan should be granted liberty and set free to go out in public places which are otherwise meant for humans. So what were those rights was yet another challenge for the court. And that was resolved by laying down a test. And the test was as to whether the behavioral, social, and physiological needs of a particular animal species are being met or not. Because in this test, it is implicit that they all have a right to life, a life of their own. It is a right of every living species not to be deprived of its natural habitats. That was an important life, and that is that right, and that is a legal right that actually is a right to life as far as those animal species are concerned. Now, as I said, the most difficult part was, I think it was too radical. And I have no hesitation in sharing with you. Some of my colleagues, I actually wanted to know their reactions. So I generally discussed, you see, that whether, and they are also judges, that whether animals can have rights. So, the reactions were quite different. Some said, rights? What do you mean by rights? And they also were very, they had empathy, they had everything, but no one wanted to cross that barrier, that line, the line of welfare. Everyone wanted to stay there. The empathy was there, no doubt about that. But in order to cross that line, and some, you see, actually asked me, what will our children do? What about our grandchildren? How will they see an elephant? Will they go to Africa? Will they go, where would they go? So I knew that I was doing something probably which appeared to be very radical. But once that radical thing happened, but I must say that the young people were very, very supportive. And even the older ones, the media of Pakistan was very supportive. But the moment the judgment was rendered and it became an attention of the internationally, it started making difference and making it easier for the court to have the judgment implemented. There was resistance from the government, there was resistance from the zookeeper, there was a resistance even from within the board of the Wildlife Board, which had petitioned for that bear. They filed a review. They wanted to delay the relocation, and that was refused to them. That was refused, and their petition was dismissed. But then the implementation took some time, and ultimately in December, in July 18, 2020, I passed another order, again explaining the judgment and the jurisprudence that had evolved. The government actually filed an affidavit. They wanted to give them an opportunity to improve the conditions and bring it at the level of the international minimum standards. And I made them understand that captivity, you see, is something that in the most equipped zoo or the best of the care, it is not a substitute to natural habitat. And it had to be made an example. It had to become a symbol for recognition of the rights of all non-human beings. And I was very, very careful, even in my wordings, because I thought that if it is too radical, it may be overruled by the Supreme Court. So, my judgment says it all, that the animals have rights, and it's their right to be dealt with according to their behavior, according to their social and physiological needs. And they cannot be achieved in captivity or even the best of the zoos. That can only be achieved in their natural environment and their natural habitats. So, it was not, you see, again, the rights they possess is because they have interests. And it is a duty of care as far as the humans are concerned. They have the duty to fulfill, and that is where, with profound regards to the judgments from the United States, that is where I had a different view, that it wasn't necessary for the right holder to also have duties, you see, or be capable of performing duties, or capable of fulfilling society's obligation or other duties. So, yes, if it is in the interest of an animal, say for instance, an animal can be an animal, what about the pets, you see, who lose their homes? They have to be kept somewhere. But the message was very clear that they have rights, they cannot be kept in captivity, the captor has to discharge the onus. So the captor has to discharge that onus, that it is not only for compelling reasons, but it is in the interest of that animal species to be kept in a place other than its natural habitat. And this was when the court said bon voyage, and this was a written order to Kaavan, that he became a torch bearer, not only because, let me share with you another experience. As long as I was dealing with this case, no one actually was interested in any other animal beings. The entire focus was on Kaavan. And everyone wanted him to be out of the zoo. But he became a symbol for all those non-human beings who were incarcerated, who were inmates of the Marghazar Zoo. And ultimately, this is how the recognized rights were ultimately enforced. And the best, I think, it was summed up by the New York Post with the headline, Pakistan Zoo that housed world's longest elephant closed for good. Captivity is against the right to life of the animal species. Depriving them, capturing them and depriving them of their natural habitats is against their right to life. Now, right to life as far as animal species is concerned has to be interpreted and classified according to their every species separately. They cannot be equated with any other species, let alone the humans. So, ladies and gentlemen, the message of and the jurisprudence of the Islamabad High Court is that all living species and non-human animals possess rights, they have interests. It is a duty of the human species because of their higher cognitive abilities to take care of them and to protect them. Ladies and gentlemen, this was a judgment which I rendered later. This judgment was regarding encroachments made and destruction of habitats in the national park. And again, you see, the rights of flora and fauna were again recognized. But recently, just a few days before coming to attend this conference, I was on a bench in the Supreme Court, and there a petition was filed by a zoo, an appeal was filed in the zoo seeking permission or directing the management and scientific committees to grant permission for import of elephants. But that on the basis of the Convention on International Trade in Endangered Species of Wildlife, Flora and Fauna. This is an extremely important, and I think the European Union would be able to play a very significant role. This is where the developments are heading towards recognizing the rights of the animals, though not directly, because recently they have interpreted the definition of the appropriate and acceptable destinations. And it is in the context, it is directed towards promoting in situ conservation. So even the trade, you see, the international trade, and this is regarding, the definition is in the context of the listed animals in Appendix 2. So that appeal has been dismissed, and soon the judgment, when I get back to Islamabad, would also be released. So ladies and gentlemen, I end up my presentation with Robert Thru's quotation that the only creature on earth whose natural habitat is the zoo is the zookeeper. Ladies and gentlemen, the looming crisis, the environmental crisis, has put the human species at risk, and which the human species actually do not realize till now. the glaciers are melting, the catastrophic consequences of climate change have become obvious. Time is running out. It is for the human species to wake up and to realize that all living species have intrinsic value, they have rights, and they ought to be protected. And it is the duty of the human species to protect them. And thank you very much.